welcome along to our next instalment of our employment law podcast. I'm Nicola Gray from Aberdeen Constein, employment partner based in Aberdeen, and I'm delighted to be joined by Marianne McJanet, our employment partner based in Glasgow, as we take a look at some of the key changes that were coming down the line, largely from the Employment Rights Act, that are going to take effect during the course of 2027. The one that kind of grabbed the most headlines and was probably one of the most contentious points was in relation to the unfair dismissal qualifying period. It was to be a day one right, and then it wasn't, and it was coming through to that. But Marianne, where did it ultimately end up?
I know, it was exhausting. It was exhausting going back and forward. We were constantly worrying about what we were having to do, but it finally landed on a reduction from the current 2-year period to 6 months. So the proposal for the day one right has been dropped. There's now going to be a period of 6 months, so someone has to be employed for 6 months before they can bring an unfair dismissal claim. This is far more reasonable, and again, there's going to be changes required for employers planning and with this change, but it doesn't feel like it's going to need to be as extreme as it was going to be with the day one right. So there's a bit more movement around that, and it seems there's not going to necessarily be the kind of complexities around probationary periods and things like that. There's still going to be probationary periods within contracts, as we would always advise people to utilise your probationary periods, and don't come to us at 6 months time and say, oh, they've been terrible since throughout a probationary period, as we sometimes get, but really utilising that and addressing issues and getting the right people in place. But it's not going to be a day one right, but it's going to be a 6 month right.
6 months, right. And I think probably we've all relaxed marginally in the employment law world, because we've some of us that have been too long in the tooth will recall it being a year, and perhaps those that will be aware that it was 6 months, but right at the start. So it's something we're a bit more relaxed, and it's therefore done away with a lot of the consultation that was otherwise going to need as to what the statutory probationary period was going to be. So it comes back to what we would be generally advising.
Yeah.
The Employment Rights Act really was, championed to enhance employment protections, and one of those that's come through, as well as the pregnancy and maternity protections. How are they being strengthened during the course of next year?
So in next year, pregnant workers and those returning from maternity leave are going to receive enhanced protection against dismissal. So that relates to redundancies, it relates to a period following their return in which they're going to have enhanced protection. And there's been a lot of campaigns. The most notable one was the one run by Pregnant Then Screwed, which really kind of brought to the surface a lot of discriminatory behaviours that women returning from maternity leave were subject to, and being forced out of jobs simply for having taken maternity leave, although that was obviously never the reason that was given by their employer. So those sorts of enhanced protections have come as a result of campaigns and kind of legislation and case law that we've seen over the last couple of years around that. So those enhanced protections are going to be in place from next year.
We're also going to see a right to statutory bereavement leave. That's a new right coming in. So what do we know about that?
So a statutory right for bereavement leave, it's when someone has obviously suffered a loss, it's going to be, we've still to wait whether it's going to be paid or unpaid, but it's then going to give people the statutory right to time off, similar to compassionate leave, but making it a statutory requirement in there. And again, if you're then saying it's paid, or is it paid for a period or paid for a couple of days or whatever it is, that then has a kind of financial impact on the business itself.
It does. Hopefully we'll give a bit more structure, but yes, it certainly will maybe will come at a cost one way or the other with that carved out protection. There we'll see changes to 0-hour workers. That was another one of the big tickets as the bill was progressing through. What are the changes there to 0-hour contracts?
Yeah, so when we first heard about the kind of make work pay proposals that we got from the government last year, The government were seeking to try and address the sort of one side flexibility that they felt that, you know, the employers who had kind of employees working, or workers working on 0 hours contract had. So it's complicated. The wording within the legislation is complicated, and it's quite long. So there's going to have, workers are going to have the right to guaranteed hours, which then kind of doesn't quite sit with it being a 0 hours contract, or, you know, adds some confusion to it, but also then kind of pay for any cancelled or shortened shifts. So if someone is due to work an 8 hour shift tomorrow, for example, and they get notified at 3 o'clock the day before that they're no longer needed, there's going to be pay for that, or certainly compensation for that, or if they were due to work an 8 hour shift and they only are required for 2 hours, then there's going to be a change around that. It is complicated, and I think we do need some more clarity around how it's going to impact, and whether or not we're going to move away from 0 hours contracts in their entirety. That would be strange. It would be difficult in the hospitality sector, for example, to completely move away from it. But I think we are still a wee bit away. We're still a good year out from it, of needing some more clarity around that.
Yes, I think hopefully that will come, because it's really looking to protect that regularity of the arrangement, isn't it? Where there's going to be kind of that pattern of hours that then becomes the opportunity for it then to be guaranteed hours, which still allows, hopefully, as things stand, there to be that mechanism where there's genuinely a need for that kind of 0 hours kind of arrangement, which can suit both sides of the party. It's not just an employer tool, but then protection is certainly then to kick in, probably again for both sides, where there's going to be that kind of adoption of kind of a regular pattern of work that comes with it. Exactly. Speaking about flexible working, and 0 hours contracts is one way to that. What's the changes to the flexible working regime that we'll see next year?
So flexible working has become a day one right, you know, so that's been a big change for employers over the last year or so. There's going to be requirement of where an employer refuses a request, they need to give reasons, and they need to explain why the refusal is reasonable. I would say a lot of the decisions just now kind of do go into why it's reasonable, or why they feel it's reasonable, but it's going to be a requirement. I think particularly when that's kind of working alongside a lot of this come back to the office, and you've got to be working in the office, it's going to be quite difficult for people making flexible working requests, but it's not. And it's going to be difficult for employers in terms of rejecting them or refusing them, but it's not going to do away. The mandating people to come back to the office is not going to do away with people's right to be able to request to work flexibly. And it's a reminder that flexible working is not just about where someone works. It's how they work. It's, you know, the hours that they work. It's a variety of different things that make it flexible. So a lot of employers say, well, we can't have flexible working, but actually what they really mean is we can't have home working. They can have flexible working, you know, but it's just looking at that and looking at kind of business needs and why you would be refusing that. So that's going to be coming in next year.
Clarity on that. Reason that's there. Thank you. On clarity, if we have anything further in relation to these harassment obligations that we've heard coming through with all these steps, these reasonable steps, what does that mean?
So the legislation is hopefully going to spell out what reasonable steps mean, and what they are. It's quite a difficult one. You know, it's almost the kind of the employment lawyer's equivalent of how long's a piece of string. Reasonable steps for one organisation might not be reasonable steps for another organisation. So it will be interesting to see how the legislation sets that out. Are there going to be banding for, you know, the number of employees that you've got and what reasonable steps will be, or the sector that you work in, and or, you know, whatever it can be. So we'll see, hopefully get some clarity around that, which then kind of should cut down on any sort of debate and, you know, cases being brought around it. in theory.
Continues to be a movable feast with the introduction of the requirement, then the all reasonable steps, and now the hopefully clarity in relation to that. Another building point is in relation to the gender pay gap and menopause action plans becoming mandatory. That's 2027, isn't it?
Yeah, so we spoke about in the previous podcast about this becoming voluntary in April of this year, but from 2027 it's going to be mandatory. So it will impact employers of a certain size, so with over 250 members of staff, and that's why it's quite good to be putting in the voluntary groundwork just now and this year before it becomes mandatory next year, and putting in place these equality action plans to ensure that there's gender pay gap reporting, that there's menopause action plans being put in place to look at the diverse workforce that we have in operation now.
And to circle back, I suppose, to unfair dismissal, when we were speaking about that right in the start of this kind of Employment Rights Act in 2027 changes, there was one of the concessions that then probably got it over the line for there to be that 6-month period rather than the day one right was a change in relation to the compensation for successful claims. And what was that change, Marianne?
And that kind of felt like it came almost out of nowhere. It was we hadn't been discussing it at all, and then at the very last hurrah, it was, oh, and we're going to scrap the cap for unfair dismissal compensation. So just now, unfair dismissal compensation is capped at I think it's £118,000 or 1 year's salary. Can't say if the figures are absolutely correct off the top of my head. Just now,
118 and loose change, I think, would
and
be
loose
enough.
change. There we go. But just now in discrimination claims, we all know that they are uncapped. So there's a greater risk when a claim for discrimination is brought against an employer. And now we're going to see unfair dismissal claims being subject to that uncapped limit as well. So again, they're looking at it from whether you're going to settle, what's the encouragement for someone to settle a case at a conciliation point or prior to a tribunal, if they know, well, I could get an uncapped amount if I'm successful at an employment tribunal. And I think we'll see a lot of cases maybe then potentially running to see if what people might get at that uncapped level. But again, it's huge. It's a huge change because businesses often, when they're looking at an employment tribunal claim for unfair dismissal, know that, well, the most that we're going to have to pay is 1 year's salary. And if that's getting taken away, there's that kind of less comfort or security in defending an employment tribunal claim in an unfair dismissal proceedings if that's taken away.
Be harder to put contingencies in place for those who are required to report on these matters, apart from those for the insurance field, perhaps taking a view at, and I'm sure step in.
Yeah, and I think we'll be seeing a lot more kind of opinions having to be sought, for the likelihood. So us either engaging in them ourselves and having to provide opinions to clients, having to engage counsel for getting opinions, and I think, as you see in any insured sectors where that's what you have to do when you have insurance funding in place for an employment tribunal claim anyway. They want an opinion on the kind of likelihood of success, and I think that's certainly maybe where we'll move to a lot.
And when do these changes, 2027 changes, take effect, Marianne?
So a lot will come in from the 1st of January, but they will be gradually brought in throughout 2027. So again, probably the April and October dates will be the key ones, as they are this year and every year. And we'll just see kind of how they all fall into place alongside a general election or a Scottish election, potential other elections taking place in the kind of the wider chaos of the world that we're in.
Absolutely that, and we'll keep everybody posted as much as that we're able to do that. Thank you very much for running us through that, Marianne. No, as always, if anybody, watcher or listener, has got any questions, then get in touch with Marianne, myself, or any member of the employment team, and we'll be happy to lend you support where we can.
Thank you.
Thank you very much, folks.